Okay, so Ms. Dugas is on probation for the offense of robbery, a second-degree felony. We were previously here, and she entered pleas of true to counts 1 through 12, all of the counts in that motion, second amended motion to revoke unadjudicated probation. I received the updated pre-sentence report as well as a letter from Ms. Dugas. Has everyone had an opportunity to review that? Are there any additions or corrections?
None from the defense, Your Honor. No, mistake.
All right, and this was unagreed, correct? Ms. Holmes, you may proceed.
Thank you, Your Honor. Spoken with Ms. Dugas, obviously the various new offenses and violations is not acceptable through probation. She understands that. She stated that throughout this time, she did not have much support. She was going through a hard time in life, and she resorted to doing and committing these offenses, not being in obviously the right state of mind to be able to successfully complete probation. Ultimately, Ms. Dugas is requesting to have the opportunity to be reinstated to complete probation, and she would like to address the court in regards to this as to her plan of how she can successfully complete if given the opportunity.
Okay, go ahead.
Ms. West. Complete this probation.
All right, folks, buckle up. This courtroom drama is intense. The video opens with Miss Dugas standing before the judge, and you can feel the weight of the moment. She's already on probation for robbery, a second-degree felony. But instead of staying on the straight and narrow, she's piled up a fresh list of violations: drug possession, resisting arrest, and failing to report to her probation officer. Her defense? She was going through a rough time, lacked support, and wasn't in the right state of mind. But let's be real. Those excuses don't carry much weight when you're already on probation for a serious crime. The judge isn't buying it, and honestly, neither are we. The court reminds her that probation was her second chance, and she blew it. The verdict? 8 years in prison. And here's the kicker. If she gets into trouble again after this, she'll be classified as a habitual offender, meaning a minimum of 25 years behind bars. That's practically a lifetime. It's a harsh reality, but the message is crystal clear. If you're given a second chance, don't waste it.
I know it's going to be extended if you do fight to. Like any job, I'm great. I'm being like that on family. You never be found the world.
Ms. Dugas, you did the exact same thing. You robbed someone else while you're on probation for robbery. Not just rob someone else. You failed to ID, failed to report to probation. You committed the new offense of possession of a controlled substance. You resisted arrest or... It's ridiculous to me that you're saying you want a second chance, because this was your second chance. You've already been on probation. You were given the second chance of not going to prison. The fact that Ms. Holmes negotiated a cap of 8 years for you, you should thank your lucky stars. This is ridiculous. 8 years, in my opinion, is not enough. You had every opportunity to do all the things that you're Stop crying, because you weren't crying when you were robbing people and using drugs and not being a good mom and not doing the things that you should have done when you were given this opportunity. Right? Ms. Malfino?
Now, let's turn to Mr. Antwine's case. And trust me, this one is even more intense. He was on deferred probation for aggravated assault involving family violence, a serious charge. But instead of staying out of trouble, he committed another domestic abuse offense, this time in Louisiana, and worse, it was by strangulation. Seriously, this somehow, judge doesn't hold back. She lays it out. He had access to mental health programs, community services, and other support systems, but he ignored them. Now, he's in court again, pleading for leniency, but the judge isn't having it. The sentence? 15 years in prison. And honestly, it's hard to argue with that. His actions weren't just violent, they were repetitive. That's a massive red flag. This case is a stark reminder. The justice system prioritizes protecting victims and holding offenders accountable. And in this instance, that's exactly what's happening.
Sorry.
I don't think I need to add anything to the court. I think, did you follow the agreement? age at the very least is appropriate for her based on the number of violations. I spoke with Mr. Chen yesterday. He does not want to continue to work with her. This is actually her third MTRP. It's about her fifth chance in front of you, not just her second chance in that declaration is purposeful.
Ms. Dugas, I'm going to find that you entered your pleas of true to counts 1 through 12 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of robbery. Going to sentence you to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. I hope you take some advantage of this and actually do what you're saying you're going to do when you get out and change your life. There's programs in prison. Take advantage of them, but you're not going to continue to get opportunities like this. If you continue to violate the law after this, you're going to be considered a habitual offender. And if you do anything again, your minimum punishment is going to be 25 years. 25 years minimum for what you've been doing. So you need to change your life or you're never going to see your kids, right? Go back with.
These cases highlight one of the biggest challenges of probation. On paper, it's an opportunity to turn your life around. But as we see here, it doesn't always work out. Ms. Dugas and Mr. Antwine both had the chance to get back on track. But poor choices, personal struggles, and a lack of accountability kept pulling them in the wrong direction. The takeaway? Probation isn't a free pass. It's a second chance that comes with serious responsibilities. And if you don't take it seriously, the consequences will be severe. The judge's message is loud and clear. If you're given a chance to reform, don't take it for granted. Because if you do, you might not get another one.
And Mr. Antwine is here for sentencing on probation, a deferred probation for aggravated assault, family violence, and that was a 10-year deferred probation that he was given back November 14th of 2023. Entered pleas of true, it looks like, to counts 1 through 11 in the motion to revoke unadjudicated probation. I've received an updated pre-sentence report. This was an open plea to the court. Is that correct?
Yes, Your Honor. The court had previously, when we were here before, it advised the court, that he received 4 months on that new case in Louisiana, but it does involve the same victim, Miss Red, as his case here.
Mm-hmm.
We had discussed 6. The court did not feel comfortable with that, so we've just decided to go on to you.
Okay. All right. So that's what, and I wanted to remind myself, I had a notation on this about that new offense. So the new offense was in Louisiana, and it was domestic abuse, battery, also by strangulation, correct? Against the same victim. All right. Mr. Lewis, you may proceed.
Judge, in this situation, of all my conversations with Mr. Antwine here, a lot of his issues come back to his mental health problems. And at the time, I believe he was not really open about getting the help that he needed with these issues. And once he got on probation, of course, those issues really became a very unstable situation. He admitted that he was homeless for a period of time there, which is why he went back to Louisiana. All of his family is there. We had some sort of support system. But Judge, he understands that he did mess up. He understands that,
One thing that stands out here is how the judge handles these cases. They're firm but fair. They acknowledge that personal struggles are real, but they don't excuse criminal behavior. The court's stance is simple. If you're given a second chance, make it count. And let's talk about the reality of habitual offender laws. If Miss Dugas messes up again, she's looking at a minimum of 25 years. For Mr. Antwine, it's already 15 years, and the judge makes it clear that he's lucky it's not more. These cases serve as a stark wake-up call. Probation isn't an easy way out. It's a test. And if you fail, the consequences are steep.
You weren't working, you didn't have your mental health, you didn't do your community service, you didn't do the batterers intervention prevention program, which probably would have taught you how to not beat on and attack and put your hands on people that you supposedly care about. Got a new offense over there for that. Anyway, I'm going to find that you entered your pleas of true to counts 1 through 11 freely and voluntarily. I'm going to find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault on a family victim. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the laws give you the right to receive. I believe the initial was yes. I am going to make the finding that there was a deadly weapon in that initial case. I'm going to hand you the trial court certification. You need to sign this with Mr. Lewis. It shows that this was not a plea agreement. You have some rights to appeal. You can talk to him about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Good luck to you, sir. Sign that, and then you can go back with the bailiff.
So, what's the big lesson here? Probation is tough, and it's not for everyone. These cases show just how difficult it can be to stay on the right path, especially when life gets complicated. But they also prove that the justice system has its limits. It will give second chances, but it won't offer unlimited patience. If you're given an opportunity to turn things around, you better take it, because third chances? Those are rare. The judge's final words to both defendants are a mix of warning and hope. Use the programs in prison, change your life, and don't come back here again. It's a sobering reality check. Actions have consequences, and the court isn't afraid to enforce them. All right, that's a wrap on this one. Let me know your thoughts in the comments.